last night at around midnight, someone went to Mr. Johnson's house wearing a ski mask, knocked on his door, and Mr. Johnson answered the door.
This is State of Ohio versus Olivia Clendenin. Case number is 25CR42324. Ms. Clendenin is present with her counsel, Lindsay Arway. The state is represented by Brian Goodyear. We're here for a bond hearing. What's the request?
Thank you, Your Honor. Ms. Clendenin, I believe, is actually requesting to have the monitor removed, understanding that that is a pretty lofty request. The basis for that request, Your Honor, is that at this point, I know that she has her main employment with the cheer and tumbling facility. However, she is also working, is it Soray? Is that Soray Wellness, which is actually LA Tan, and she is up for a promotion with that company into management. As part of that promotion, which she tells me they are looking to officially promote her as of January 1st of 2025, she would be required to have a dress code. I don't know that the dress code's necessarily the biggest issue. I think the biggest issue is that as part of her promotion, she would be required to utilize some of the wellness services so that she's able to appropriately advise customers and clients as to those services, and it has the potential to very much damage the monitor itself. And I know that those are very expensive. I think we had a client who was told that they cost somewhere in the range of $3,000. So.
Anything from the state?
Your Honor, this is like deja vu all over again. Ms. Clendenin was almost exactly this many days from the last jury trial setting when she asked this court to remove her monitor at that time. The court had a chance to consider that request, denied that request, and then shortly thereafter, Ms. Clendenin fired her attorney, from my perspective, for reasons that I still don't understand. I know for a fact, in speaking with him at the time, that Ms. Clendenin never even spoke with him about it. She never gave him any reasons. There was never any problems, any concerns. He just found out she had a new attorney. So, Your Honor, I just bring this back initially to the fact that she's charged with attempted murder, and she nearly killed someone. And she confessed to the fact that she nearly killed someone. And luckily for her, she had people with resources sufficient to secure her release from jail. And I understand that, as the motion mentions, she's not tested positive for any drugs during the time she's been out. However, having said that, the state's main concern is her appearance at trial. The fact that she tried to get off the monitor 30 days before trial the last time, it was denied. She finds a way to continue the trial. Now here we are once again, the same period of time before trial, asking again. It just is very concerning to the state that what really is happening is she's trying to get a 30-day head start. She knows, I'm sure, like everyone else knows, if you cut that monitor off, they know immediately it's done, and they'll come out and they'll try and arrest you immediately. Judge, this is just such an odd conversation to have. I'm about to be a manager on January 1st, but I'm going to trial on January 26th in a case where, Judge, even if she's only convicted of improperly discharge of a firearm into a habitation, if that's the only conviction she received, to which she confessed, she faced a minimum of 10 years in prison. Minimum of 10 years in prison. So she has a massive incentive to run, to not appear for trial. And frankly, it makes this thinking, this motion, to me, almost nonsensical. You're going to be a manager for 25 days, and then you're facing a minimum of, best case scenario, probably, with the charges that exist, 10 years in prison. So I think that, Judge, it's the state's perspective that the overall situation here is very concerning. We would ask you to deny both the requests. She's facing serious prison time on serious charges, and I think she's been given a lot of leeway up until this point considering those factors. So the state would ask you to deny both. Judge, the victim's mother is present. She would like to address the court as well.
Okay.
Speak on behalf of my son. I heard what this was about today. And I think it's absolutely absurd that she's requesting this when my son can't even hold a job down since this happened because of the injuries that he's sustained, the stress that he's gone through, the mental anguish that he's experiencing because of her actions, and that she has the audacity to come in here and ask for this to happen before the trial because she would like a management position with a job that she's holding right now. It just makes no sense to me whatsoever, Your Honor, when my son, because of her actions, can't even hold a job down right now. I can't believe that she's even asking that. So that's all I wanted to say.
Okay, well, you said it well. That's a logical statement. I understand. So thank you.
Thank you. Appreciate it.
Okay.
My name is Misty Johnson. Yes. Thank you.
So basically, she's presumed innocent as far as where we are on this. I'd already sort of come to this conclusion before I heard from the victim's mother, but it makes a lot of sense. I mean, when something happens like this, there are consequences. And I don't think she's going to run. I don't believe that. I'm not concerned about that at all.
I would suggest that's not a concern as well, Your Honor.
She's, number one, shown she can comply. I mean, this probably, regardless of the attitudes about it and the understandable attitudes about it, it seems like a very unusual thing given her history, but it happened. And it doesn't make sense to go ahead and make these changes. Here we are 30 days from trial. All right, so the request is denied. I will modify her hours from 6 a.m. till 10 p.m. However, on New Year's Eve, you stay home. This is case number 25CR42324, State of Ohio versus Olivia Clendenin. Ms. Clendenin is present with her attorney, Lindsay Arway. The state is represented by Brian Goodyear. We're here today for a jury trial. It's 9:04 a.m. I think all the jurors that are going to show up, well, all the jurors who have shown up have checked in. So we're getting very close to starting. I'm told that counsel wanted to put something on the record prior to bringing in the jury.
Yes, Judge, two things. First of all, I just wanted to make the court aware of something. I realize that this is not anything the court can take action on, but it is very concerning to the state, and so I want to at least make a record of this. The victim in this case, his name is Daniel Johnson. Last night at around midnight, someone went to Mr. Johnson's house wearing a ski mask, knocked on his door, and Mr. Johnson answered the door, and the individual tried to get him to come outside, and he would not agree to do that. This individual made comments to Mr. Johnson about, he identified himself as being the father of a good friend of the defendant. He indicated that he could pay Mr. Johnson $500 an hour for a week if he would do this job for him. And ultimately during this conversation, Mr. Johnson told him, I don't want anything to do with you. He shuts the door. He looks outside the peephole a few minutes later and sees the gentleman still standing there. He opens the door, and the guy says to him, I just want to make this right for everybody. So obviously, now Mr. Johnson called the police. They made a report. I'm sure they will investigate the matter. There is a ring camera of this gentleman being at his home a few days before that as well. I think that was a couple days before that. This same gentleman was at his house when he was not home. So again, like I said, Judge, I understand that you can't take any action about this, but it is very concerning to the state of Ohio. And I would ask that you instruct the defendant and her family that if they do have anything to do with this gentleman contacting the victim as a very serious matter, because frankly, it was very clear from the rendition of what happened that I was told that this individual was attempting to pay him money in relation to this case.
I don't know if that's enough for me to assume that the defendant has any knowledge or information related to this. Her attorney's here. She can talk to her about things like that happening that may or may not be under her control. But I don't think it's appropriate for me to do that. So the police have been called. They're investigating. I expect that they'll get an answer on this. It's clearly something. It could be a crime.
Yes, sir.
Okay. Anything else?
No, Your Honor.
All right. Anything else, Ms. Arway?
No, Your Honor, thank you.
Okay. State of Ohio versus Olivia Clendenin. Case number is 25CR42324. Ms. Clendenin is present today with her attorney, Lindsay Arway. The state is represented by Brian Goodyear. We're here for sentencing. Mr. Goodyear, are there any statements from the victims?
Judge, yes, I would actually like to speak first, and I'll have them come and speak to you if that's okay.
That's fine.
All right. Judge, first of all, I want to start by saying that we're asking for restitution for 2 separate victims in this matter. I think it's part of the precinct's investigation, but there's a request for $750 to Pamela Wadsworth for damage that was caused by the defendant when she had the accident you heard testimony about, and then $1,390 to Daniel Johnson, which is amount of money left over. There's a little bit of damage to some of his property during this, and then also money left over after insurance covered his medical bills.
All right, Ms.
Your Honor,
Arway,
I'm sorry.
I thought you were finished. Do you have more restitution?
That's the rest of it. So the total amount we're requesting is $2,140, $750 to Pamela Wadsworth, and $1,390 to Daniel Johnson.
Okay, is there any dispute over the amount of the restitution?
For purposes of the restitution, we would agree to that amount, Your Honor.
Okay. Go ahead.
Judge, I know you had a chance to read my sentencing memorandum. I go over some legal issues in detail, but I want to create a record of those issues as well during our hearing today. There are factors you have to consider in determining what the sentence should be. One factor I think that's very important in this case is whether or not there's serious physical harm to the victim. And, you know, Judge, you had the chance during the trial to listen to Daniel Johnson testify. You had a chance to listen to his mother testify, and you had very detailed testimony about what this injury did to him then, what his process of attempting to heal has been, and the fact that he's not completely healed even as of this day. And I would submit to you, Judge, I mean, it's clear from the testimony he nearly died. He was shot in the abdomen and nearly died, and he went through excruciating pain for a substantial period of time. I don't think there's any doubt that you can say he suffered substantially. He had to live through substantial suffering, as the statute talks about. So I don't think there's any doubt, and I don't think the court would say there's any doubt that he suffered serious physical harm, serious injury. And then the second question is, well, we have a defendant who has no real substantial prior criminal history, but we have a very, very serious case. And so where does that sentence lie? How should the court balance those things? And from the state's perspective, and I mentioned this in my memorandum, there's no question in my mind that I can tell you from my experience, not only dealing with this case, but having listened to both the jail calls and the home wave calls that she's been engaged in, the defendant has since the time she was convicted, she has absolutely zero remorse for this offense. I can say, I don't know that I've ever heard someone with less remorse than she has for this offense. And I mentioned some calls in my sentencing memorandum. I described them. I want to play one for you, which I think sums up her attitude, and I think, frankly, is indicative of the way she views this case in total. This is going to be her and her mom talking about the reaction to the verdict.
Your buddy said he's been on Facebook and nobody's posted anything. Not yet.
I just can't believe, like, how nobody was thrilled when this is what they wanted.
I really thought they'd be like hugging and laughing, well, not laughing, but hugging and basically celebrating this, but they weren't. They weren't. His mom, his grandma, especially not Daniel.
No.
Yeah, he was crying.
Yeah.
I mean, you're running a young girl's life. How could you not be upset?
You're ruining a young girl's life. How could you not be upset? That's her reaction to the verdict. She sat here and listened to Daniel Johnson testify, listened to her mother. She knows what she did. And her response to all of that is that the victim, because he participated in the prosecution in this case, is ruining a young girl's life. And I'll tell you, Judge, I've listened to almost all the calls she's made since sentencing, and that attitude is the attitude she's had throughout the entire process. And I think when you look at the recidivism factors, which is what we're talking about, when you think about someone who is more likely to commit future crime versus less likely to commit future crime, one thing, despite anyone's prior record, one thing that exists throughout the statutes is whether someone shows genuine remorse. And I think that she is the exact opposite. She shows zero remorse for what she did. Your Honor, depending on how you calculate this, the minimum sentence that she faces is either 11 or 14 years, depending on the way you look at the specifications. And I would just say, Judge, I would argue to you that for the defendant to receive a minimum sentence in this case would demean the seriousness of the case. I think that a sentence of 11 or 14 years would not be appropriate knowing the nature of the case we have. And I would also point out to the court, obviously, Judge, you understand what I'm asking for. I'm asking for the maximum sentence in this case because I think it's appropriate, and that's in my sentencing memorandum. Even take her comments and her lack of remorse away. Someone who nearly kills someone in these circumstances, from the state's perspective, receiving the minimum sentence would demean the seriousness of these offenses. So, again, frankly, I don't think I've ever heard someone care as little as she does about what she did. So, Judge, I would ask you now to allow the victims to speak to you as well.
All right, thank you.
Hi, my name is Sharon. Daniel is my grandson. He's my first grandchild. And he's my heart. He's not a perfect person, but he has a good heart. He would never think of hurting somebody else. He used to be a true go-getter. He had good grades throughout school. He played football and he excelled at it. He has many friends, and I have never met anyone who didn't like him. He used to go to the gym regularly and run miles every other day. But because of one person's rage that she admitted to feeling, nothing is the same, and I don't think it ever will be. He no longer works out because it's too painful. His left side hurts constantly. He suffers from severe stomach problems because the bullet that hit his rib exploded and destroyed his intestines. And I mean destroyed. He still has several fragments of that bullet in his body, which will likely cause even more problems as he ages and those begin to move. The saddest part of all of this is that throughout the entire ordeal, she has not shown one bit of remorse or concern for the man she shot instead of the ones that she wanted to shoot. She continues to look at Daniel as if he has something to do with it, as if he would drop charges when it was the state, not Daniel, that brought the charges. Your Honor, I also want to emphasize that she was convicted of attempted murder. That's not just a mistake. That's a deliberate act. And I believe with my whole heart that if she is ever enraged again, as she described it, she will do the same thing again. Please, Your Honor, give her the maximum sentence so she can never harm another person. She may have already given Daniel a life sentence with what she did to him. So there's no amount of time you could give her to actually satisfy me. But I ask you to protect others by ensuring that this doesn't happen again because of her anger. Thank you, Your Honor.
Thank you very much.
My name is Misty Johnson, and I'm the mother of Daniel Johnson. I'm writing to share with this court the devastating impact that Olivia's actions on January 1st, 2025 has had on the life of my son, my own life, and my family's life. Before January 1st, 2025, my son was a happy, easygoing, and carefree young man. He was incredibly athletic and dedicated to fitness, lifting weights 3 to 5 times a week, and working out almost every day. He was a person who got along with everyone he met, and it seemed like everywhere we went, someone knew him and greeted him with a smile. He was a vibrant part of our community. Since that day, my son has not been the same person. He was an innocent bystander minding his own business when Olivia, in a fit of rage, decided to try to kill her husband and boyfriend. My son had nothing to do with her conflict, yet he is the one who has suffered the consequences of her violence. The trauma of that day has stripped away his carefree nature. We are now dealing with deep emotional scars that I fear will affect him for the rest of his life. Our entire family has been forced to navigate the long-term mental and emotional fallout of this senseless act of rage. Throughout the trial, I have watched her closely. She has shown absolutely no emotion or remorse, even when my son was crying out for his life. The only emotion she displayed was for herself. I personally witnessed my son, or her give my son, the most hateful look I've ever seen as she walked past him. It was clear that she takes no responsibility for her actions and instead blames him for the prosecution. I do not believe that she understands the magnitude of her actions or has learned anything from this. I believe with all my heart that if she were to get angry again, that she would repeat these actions. Because of the lack of remorse she has shown and the permanent damage that she has caused to my son, who is innocent, I ask the court to consider the maximum sentence allowed under the law. My son will deal with this trauma for the rest of his life. It is only just that she is held fully accountable for the life she has forever altered. Your Honor, thank you for considering the impact on our lives during your sentencing.
Thank you, ma'am. Good afternoon.
Your Honor, my name is Daniel Johnson, and I'm here to give some insight on how this crime has affected my life. On the day of the incident, I was attending a New Year's Day get-together. I had been invited over and was sitting on the porch minding my business. The defendant was attempting to shoot at someone else, and I was the one who ended up being shot. In that moment, my life changed for reasons that had nothing to do with me. Since that day, I've had to live with the physical and emotional damage. I was shot in the stomach. I had multiple surgeries. My recovery has not been simple, and it hasn't ended. I deal with chronic pain on a daily basis, along with ongoing digestive issues that have forced me to completely change how I take care of myself and eat. This hasn't just affected me physically, it has impacted every part of my life. My daily routine has changed. Simple things like getting out of bed and how I start my mornings are a constant reminder of what happened. Things I used to do without thinking now take planning, caution, and some are even not possible. Professionally, this has also taken a toll. The surgeries, recovery time, and ongoing health issues have affected my ability to work and move forward in the way I had planned. Personally, it has been difficult as well. My quality of life is not what it used to be. Mentally and emotionally, I have been dealing with PTSD What happened that day didn't just end when the incident was over, it has stayed with me. There is a level of stress, fear, and anxiety that I now carry that I didn't before. What makes it especially hard is knowing that I was completely uninvolved. I was simply in the wrong place at the wrong time, and I'm the one who will have to live with the ramifications. In my opinion, Olivia has not shown any level of respect to myself or my family. I have not received an apology in any form or fashion. I do not hate her or have any evil feelings in my heart towards her or anyone associated with her, for that matter. I truly am just sad, and I wish that things were different and this would have never happened. Thank you, Your Honor.
Thank you, sir. Highway, anything on behalf of Ms. Clendenin?
Thank you very much, Your Honor. To kind of address the items raised by the state in a similar order, relates to the phone call that was played. It's easy to cherry pick a call and indicate that there's a lack of remorse. I think what is relevant to Ms. Clendenin is actually what was presented during trial during her interview with the officers. And as soon as she found out that Mr. Johnson was hit, her actual reaction was, "Oh my God, is he okay?" And she was inquiring of the detective as to his status. Now, over time, people can view things differently, the impact that it has on themselves instead of looking outside of themselves, and if there is any of that to Ms. Clendenin's actions or any calls, I think that her reaction to the news of the injury is significant, and she was, "Oh my God, is he okay?" So in terms of the mitigating information, Ms. Clendenin, as Your Honor is aware, has remained out on bond during the pendency of this case, which was over a year, without any violations. She was an upstanding member of her community leading up to this. As part of her ownership of the dance studio, she would actually give out scholarships to kids in need. By that, it wasn't something where the studio actually gave money, but she would donate extra time, extra lessons to give the girls that needed an outlet a place to go. So she was providing that to her community. It's my understanding that Ms. Clendenin, also leading up to this, was attending Northern Kentucky University, so she was trying to improve her life and her standing in life. She'd recently completed a business correspondence course through Harvard University. She held a number of jobs during the course of this case and leading up to it. In terms of the value that she provided to the individuals at the studio and the positive impact that she had on those girls, one mother wrote to my office that Ms. Clendenin helped her daughter, who had just recently lost her grandfather, and that it was the only place that the child had an outlet to be able to get back to herself. And so Ms. Clendenin provided that very valuable open space to that little girl who very much needed it at the time. I would ask Your Honor to impose a sentence of 8 years as it relates to the firearm specifications, that Your Honor would merge the discharge into a habitation with the attempted murder, and we are asking the court to impose a minimum sentence at this time. We appreciate the court's time and consideration.
All right, thank you. Is there anything, does Ms. Clendenin wish to make a statement?
She does, Your Honor.
Okay, go ahead.
Your Honor, I respect this court and where it stands. I would just like to say that I care deeply about my family, my friends, my business, and those who rely on me in this world. I take great pride in the impact that I have had on my community and the children that I coach, and that I basically raise them with their parents. And I will continue to do so moving forward. And to Daniel, I am very, very glad that he is well after a difficult time he has been through. And I truly hope that he has a great future, and I wish him nothing but the best in his future. Thank you.
All right. All right, there are a lot of factors to consider in this case. I've considered the pre-sentence investigation, the statements of the attorneys, the statements of the victims, the statement of the defendant. I've considered the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. The sentence on count 1 is 8 to 12 years to be served after the 5 and 3. And the sentence on count 4 is 2 years, but that will be run concurrent with count 1 for a total of 16 to 18 and a half years.
Judge, can I just interject real quick since you're talking about the indefinite sentence?
Yes.
So the sentence you gave her on the underlying count was 8 to 12?
Correct.
So I believe that 4 years has to be added to the indefinite term. So I believe the actual term is 16 to 20 and a half years.
You're right.
So when you said 18 and a half, it's really 20 and a half.
Yeah. Other than appellate rights, is there anything that I need to address?
Judge, I calculated that she has 64 days of jail time credit.
Any dispute?
No, Your Honor.
Okay, that's,
And then just if you're going to impose court costs or not.
given her position at this point in time, I'll waive court costs.
Okay.
All right. Anything else, Ms. Arway?
No, Your Honor. Thank you very much.
Ma'am, do you have any questions?
I do not, Your Honor.
Okay, all right. That's all. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
New Year's Eve party in Warren County ended in gunfire. One person's in the hospital fighting to recover. Police say it started after a woman became angry over her ex and her boyfriend hanging out. Ken Brown is live outside of the Warren County Jail and the courthouse where he is locked up facing attempted murder charge. Ken?
Yeah, that woman's name is Olivia Clendenin. She's locked up in the jail off screen to my left here, and tomorrow she will face a judge in the courthouse behind me.
Early on New Year's Day, Clear Creek Township Police got a call to this home along Dearth Road for a man shot.
The initial call was the belief that it was a drive-by shooting. When the officers got there, they did find one individual had been shot in the stomach.
Inside the home, a celebration of the new year was happening overnight, but it wasn't until 5 in the morning when the fun ended with gunfire.
It was a New Year's Eve party. There was a girl that was involved with a boyfriend there, and her husband was there. I believe they're in the process of maybe divorcing, but maybe had not completed that yet.
Outlined in Clear Creek Township's police report are witness statements that say Clendenin was not happy with her ex and her boyfriend hanging out together.
There was kind of this three-way argument going on at the party. At one point in time, we understand that she left the party, returned. The argument continued.
Police say that verbal argument turned much more serious when Clendenin left the party a second time.
She had obtained a gun, and when she drove, she actually did a kind of a donut in the front yard, which put the driver's side toward the front of the house. The driveway's on the left-hand side of the house. She did a donut in the front yard, and as she passed the front door area, she fired off a couple shots.
One of those hit a man in the stomach. Police say the man hit was not involved in the earlier arguments. He was taken to the hospital and has already undergone one surgery. Police said as of last night, he's expected to survive. After firing the shots, the chief says Clendenin tried to drive off, but that didn't end well either.
Ended up going down the road and crashing out her car, where she sustained some injuries.
Olivia Clendenin is due in the courtroom and the courthouse behind me at 2:30 tomorrow. Jail records indicate she's facing 5 felonies. Police tell us the most serious among them is an attempted murder charge. Reporting live in Lebanon.